And welcome back. This is Newstalk once again. Thank you for sticking around.
You're welcome.
And thank you for doing this every month to answer people's legal questions. And if you do have any, 793 WKTV, and we have Barbara on the line for you this morning.
Good.
Hello, Barbara.
Hello?
Good morning.
Hi.
Hi.
I would like to know what happens when you die without a will in New York State, especially pertaining to property.
Okay. When a person dies without a will, the law has a schedule that's called the Law of Descent and Distribution. And the nearest relatives essentially are the ones who take the property. The nearest relatives also have the right to be appointed as the administrator. The administrator is called the personal representative and serves a similar function to an executor under a will. Now, generally speaking, the way this works, if you have a spouse, everything goes to your spouse and no children. If you have children and no spouse, everything goes to your children. If you have a children and spouse, then it gets divided among them. The spouse has the first right to be appointed as administrator if you have one. If you have no spouse, then each of the children would have an equal right to be appointed as administrator unless one is underage, disabled, or has been convicted of a felony. Now, if you have no children, then it goes to siblings, brothers and sisters, and then after that it will go to nieces and nephews, then aunts and uncles, then cousins, and then first cousins once removed, and I think that's as far as it goes. If you have no relatives, it goes to the state. But the myth that if you die without a will, that all your assets go to the state is not true. It does go to your nearest relatives. And it includes children who are adopted. It includes children who are born out of wedlock at some point in your life. And it doesn't matter how old the child is. If your child is 50 or 5, your children still get to share in the estate if there's no will. One of the difficulties, if you don't have a will and you have younger children, and I think this is important for people to know, that if you die without a will and your children share in your estate, you may say, well, that's what I want. But if you have children who are under 18 at the time of your death, they will receive their full inheritance at the age of 18 with no restrictions. And sometimes that's not the best thing for someone. That's why I think it's important for people with small children to consider a will so that you can provide for some period of time between 18 and whatever age you pick. Most people pick 25, where you put the money, inheritance or the money that they receive in a trust that can be handled by someone, so they don't get the full amount at once. Because sometimes a large chunk of money to a younger person can do more harm than good.
Now, is there a time limit when people have to come forward? Like if you don't have a spouse or children, maybe it's an aunt or an uncle or a cousin?
Well, when you are going through the process, you have to list. You have to do a family tree, and you have to list all the relatives, and you have to try to locate these people. So it can be tricky.
Yeah. Hello, Ken. What's your question for Mark?
My question is, can the Utica School Districts keep my granddaughter out of school legally at the age of 16?
I think they can. They would I believe they have to provide an alternate education program. I think the age is 18. I'm not really positive on that one because I know someone can leave school at 16, but I believe they have to provide an alternate education program if they do not allow her to attend school. Usually if there are disciplinary sanctions that have been imposed, they do have to provide alternate education, either a home tutor or they have some programs at BOCES sometimes for students who are disruptive, we'll say.
Hello, Deb. What's your question for Mark this morning?
Hi, Mr. Wolber. My question is, my daughter does not have a will, and she has one child. She's a teenager. But in the event something were to happen to her, what would happen to my granddaughter? Would she automatically come to us as her grandparents or go to the state? I don't know.
Okay, that's a question that comes up sometimes. It's a good question. The father of that child would have the first right to have custody, not a grandparent. You would have a right to request custody from the court, and you can ask the court to award custody to you. It's something that would have to be determined by a court at the time. Even if your daughter had a will and she named you as the guardian of her child, that does not override the right of the father to raise the child. So the father would have the first right, but you have a right, and sometimes you have cases where grandparents petition the court against the parent to have custody of a child. Just 2 weeks ago, I had one, and the grandparent prevailed, and the grandparent ended up with custody of the child over the father who wanted custody, but because of the circumstances of that case, the child had been with the grandparent for several years, was doing very well. The father had just recently moved back to the state, had had very little contact with the child. The court awarded custody to the grandparent. But if it's a situation where they're on a somewhat even playing field, then the parent has generally the first right to custody.
So if there was a dispute and the judge gave the mom full custody at the time, would he still have the rights after she had
Yes,
passed?
he still has the rights after she's deceased. He would have the primary right to have custody, while the grandparents can ask if they have a good case, they might get custody.
Hello, Katie. What's your question for Mark this morning?
Yes, Mark, if you have an ill spouse and he decides to turn the deed over the home, the deed to the home over to the other spouse in case of having to go in a nursing home, is that still a 5-year wait, or does it show that he doesn't own the property anymore? Or how does that work, Mark?
A couple things. First of all, an interspousal transfer is not subject to the 5-year rule. So we want to point out what's very important is it's not just going in the nursing home that triggers the 5-year rule, but it's the application for Medicaid. So if the ill spouse goes into the nursing home and applies for Medicaid, and they look back for 5 years and they see that the home was transferred to the spouse, that will not disqualify the person from Medicaid, and it will not cause any penalties. I would point out, though, even if the house remains in both names in some cases, as long as one of the spouses is living there, that house is exempt. But it is a very good idea, if one spouse is going to be on Medicaid, to transfer the house over to the other spouse, and that way that spouse has it. One of the things that sometimes happens, you have someone in the nursing home, you have someone outside the nursing home, like what's called the community spouse, and then the community spouse passes, and then the property belongs to the one in the nursing home, and Medicaid ends up taking it, whereas you may have been able, by doing some other transfers, to get it to the children, as opposed to letting the state take it. So
Think early.
something you can do. But yes, you can transfer it to your spouse. It doesn't conflict with the 5-year rule.
Beautiful. Thank you for coming in. We'll see
You're
you
welcome.
in April.
That sounds good.
Be a lot warmer, I think.
Yes.
And stay with us. We're back to wrap things up right after this.